Good morning, guys. Today is May 16, 2022, 8:54 in the morning. So we'll continue on our labor law, Article 228. So we're already in Part 4. Part 4, Jurisdiction of the Dole Secretary. Order of topical discussion. In order to provide for better presentation, the topical discussion herein will be presented in the following order: original jurisdiction of the Dole Secretary, appellate jurisdiction of the Dole Secretary, Rule 65, certiorari, petition from Dole Secretary's decision. Number 4, Rule 43, appeal to the CA from the Dole Secretary's decision as voluntary arbitrator. Rule 45, petition for review on certiorari to the Supreme Court from the decisions of the CA. Letter I. Wait. Number 1 pala, Roman numeral number 1, original jurisdiction of the Dole Secretary. Number 1, cases falling under the Secretary's original jurisdiction. The Dole Secretary has original jurisdiction over the following cases: indispensable to the national interest cases. Number 2, petition to certify national interest cases to the NLRC for compulsory arbitration. Number 3, petition to suspend effects of termination, administrative intervention for dispute avoidance, AIDA cases. AIDA, administrative intervention for dispute avoidance, voluntary arbitration cases, and contempt cases. Individual discussion of the above cases. For a more comprehensive discussion of the foregoing actions falling under the original jurisdiction of the Dole Secretary, the notes and comments under the following articles of the Labor Code are relevant. Number 1, petition to assume jurisdiction over national interest cases. See comments on Article 278 infra. Petition to certify national interest cases to the NLRC for compulsory arbitration. See comments on Article 278 infra. Petition to suspend effects of termination. See comments on Article 294, found in Volume 3 of this 3-volume series by the author. Administrative intervention for dispute avoidance cases, or the AIDA. Comments on Article 274, voluntary arbitration cases. See comments on Article 274. Roman numeral number 2, appellate jurisdiction of the Dole Secretary. Number 1, decisions not appealable to the Dole Secretary. At the outset, it is important to emphasize the decisions, awards, or orders that are not appealable to the office of the Dole Secretary to wit. Number 1, those rendered by labor arbiters that are appealable to the Commission and the NLRC, which has exclusive appellate jurisdiction thereover. Number 2, those rendered by the Commission or the NLRC, since they can be elevated directly to the CA by way of a Rule 65 certiorari petition, since they can be brought. Number 3, those rendered by the BLR director, the exercise of his appellate jurisdiction, since they can be brought directly to the CA under Rule 65 certiorari petition. Number 4, those rendered by Dole regional directors in simple or small money claims under Article 129 of the Labor Code, since they are appealable to the NLRC. Number 5, those issued by Dole regional directors in their capacity as ex officio voluntary arbitrators, since they can be brought directly to the CA under Rule 43 of the Rules of Court. And sixth, those rendered by voluntary arbitrators which are appealable directly to the CA under Rule 43 of the Rules of Court.
Help desk, remote access, monitoring.
Let's have a break. Number 6. Those rendered by voluntary arbitrators which are appealable directly to the CA under Rule 43 of the Rules of Court. 1.1. Appeal from NLRC to Dole Secretary and from Dole Secretary to the President eliminated. The original rendering of the Labor Code provided that the decisions of the NLRC are appealable to the Dole Secretary on specified grounds, and the decisions of the Dole Secretary rendered in his appellate jurisdiction may be appealed to the President of the Philippines, subject to such conditions or limitations as the President may direct. These modes of appeal, however, have been completely eliminated. Have been completely eliminated. Hence, there is no more appeal from the NLRC to the Dole Secretary and subsequently to the Office of the President. The current rule is that there is no appeal from the NLRC's decision. There is no appeal from the NLRC's decision. Hence, there is no more appeal from the NLRC to the Dole Secretary and subsequent to the Office of the President. Present-day rules on appeals. The only way to elevate the decisions of the NLRC to the CA is to initiate an original special civil action. Initiate. Of certiorari under Rule 65 of the Rules of Court. And the only way to elevate the decisions of the NLRC to the CA decisions is to initiate an original special civil action of certiorari under Rule 65 of the Rules of Court. Present-day rules on appeals to the Dole Secretary. Though appeals from the NLRC to the Dole Secretary were eliminated, presently there are several instances in the Labor Code that's implementing and related rules where appeals to an exercise of appellate jurisdiction by the Office of the Dole Secretary are allowed. Unfortunately, there is no single provision in the Labor Code or piece of jurisprudence which consolidates or comprehensively embodies the rules on appeals to the Dole Secretary. These appellate rules are scattered in various provisions of the Labor Code. Its implementing rules and a number of other rules of procedure as well. Below is a detailed discussion of the various appeals that may be instituted to and filed with the Office of the Dole Secretary in the exercise of its appellate jurisdiction. Number 3. Offices from which appeals to Dole Secretary originate. Appeals to the Dole Secretary may originate from any of the following offices: Dole Regional Directors, MED Arbiters, BLR Director, Philippine Overseas Employment Administration, POEA, Philippine Overseas Employment Administration, POEA. Roman numeral number 2-A, appeals from Dole Regional Directors. Cases appealable to Dole Secretary. Not all decisions, awards, or orders rendered by the Dole Regional Directors are appealable to the Dole Secretary. Among the cases enumerated earlier as falling under the Dole Regional Director's jurisdiction, only decisions rendered in the following cases are so appealable: visitorial inspection cases under Article 37, visitorial inspection and enforcement cases under Article 128, either routine or initiated through a complaint, occupational safety and health violations, cases related to private recruitment and placement agencies (PRPAs) or local employment such as applications for license or denial thereof, complaints for suspension or cancellation of license by reason of administrative offenses, complaints for illegal recruitment and for petition for closure of agency. Cases not appealable to Dole Secretary. The decisions of the Dole Regional Directors in the following cases are not appealable to the Dole Secretary but to the labor office or labor official indicated opposite each one of them. Visitorial cases under Article 289 involving examination of books of accounts of independent unions, local chapters, chartered locals, and workers' associations. Cases appealable to Dole Secretary. Article 37. Visitorial power. The Secretary of Labor or his duly authorized representatives may at any time inspect the premises, books of accounts, and records of any person or entity covered by this title, require it to submit reports regularly on prescribed forms and act on violation of any provisions of this title. Visitorial inspection cases. Visitorial power. Miscellaneous provisions. Appeals from Dole Regional Directors. Only decisions rendered in the following cases are so appealable. May at any time. Inspect the premises, books of accounts, and records of any person or entity covered by this title, required to submit reports regularly on prescribed forms and act on violation of any provisions thereof. Provisions of this title. Visitorial inspection and enforcement cases under Article 128, either routine or initiated through a complaint. Article 128. Visitorial and enforcement power. Visitorial and enforcement power. Occupational safety and health violations cases. Places, agencies. Premises. Appealable. Not all decisions, awards, or orders rendered by the Dole Regional Directors are appealable to the Dole Secretary. Among the cases enumerated earlier as falling under the Dole Regional Director's jurisdiction, only decisions rendered in the following cases are so appealable: inquisitorial power. Cases not appealable to Dole Secretary. The decisions of the Dole Regional Directors in the following cases are not appealable to the Dole Secretary but to the labor force or labor official. But to the labor force. Indicated opposite each one of them. Inquisitorial cases under Article 289 involving examination of books of accounts of independent unions, local chapters, or chartered locals, and workers' association to BLR Director. Small money claims cases arising from labor standards violations in an amount not exceeding 5,000 pesos and not accompanied with a claim for reinstatement under Article 129 to NLRC. Cases submitted for voluntary arbitration in their capacity as ex officio voluntary arbitrators under Department Order Number 33/07 Series of 2007 to Court of Appeals. Union registration related cases such as denial of application for registration of said unions to BLR Director, decision on petition for application or cancellation of registration of said unions to BLR Director, notice of merger, consolidation, affiliation, and change of name of said unions to BLR Director, CBA related cases, application for registration of single enterprise CBAs or petition for deregistration thereof to BLR Director, petition for denial of registration of single enterprise CBAs or denial of petition for deregistration thereof to BLR Director. Note must be made as regards requests for SEBA certification when made in an unorganized establishment with only one legitimate union over which the Dole or Regional Director has original jurisdiction to issue the SEBA certification being requested. The rule, however, becomes different once the requesting union fails to complete the requirements for SEBA certification during the validation conference before the Dole Regional Director, in which Dole Secretary. Ipota. Occupational safety and health violations, cases related to private and investment agencies, safety and health violations. Private recruitment and placement agencies. Appealable to the Secretary. EBA is under Department of the number 83-07 series of 2007 to Court of Appeals. Union registration related cases such as denial of application for registration of said unions to BLR directors, decision on petition or revocation or cancellation of registration of said unions to BLR director, notice of merger, consolidation, affiliation and change of name of said unions to BLR director, CBA related cases, application for registration of single enterprise CBAs or petition for deregistration thereof, the BLR director, petition for denial of registration of single enterprise CBAs or denial of petition for deregistration thereof, the BLR director. Note must be made as regards to request for SEBA certification when made in an unorganized establishment with only one legitimate union over which the Dole Regional Director has original jurisdiction to issue the SEBA certification being requested. The rule, however, becomes different once the requesting union fails to complete the requirements for SEBA certification and during the validation conference for the Dole Regional Director, in which event such request should be referred to the election officer for the conduct of certification election, which necessarily would mean that such certification election should now be conducted under the jurisdiction of the mediator arbiter, to whom the election officer is duty-bound to report the outcome of the election proceeding. Certainly, the ensuing certification election cannot be conducted under the directive of the Dole Regional Director without the participation of the mediator arbiter, who under the law is the one possessed of the original exclusive jurisdiction over certification election cases, including the proclamation of the waning SEBA. On this topic, request for SEBA certification, please refer to the notes and comments. Article 268A, Article 232, 268, 234. Representation issue in an organized establishment. In organized establishments, when a verified petition questioning the majority status of the incumbent bargaining agent is filed by any legitimate labor organization, including a national union or federation which has already issued a charter certificate to its local chapter participating in the certification election, or a local chapter which has been issued a charter certificate by the national union or federation before the Department of Labor and Employment within the 60-day period for the expiration of the collective bargaining agreement, the MED arbiter shall automatically order an election by secret ballot when the verified petition is supported by the written consent of at least 25 of all the employees in the bargaining unit to ascertain the will of the employees in the bargaining unit, to ascertain the will of the employees in the appropriate bargaining unit. To have a valid election, at least a majority of all eligible voters in the unit must have cast their votes. The labor union receiving a majority of the valid votes cast shall be certified as the exclusive bargaining agent of all the workers in the unit. When an election which provides for 3 or more choices results in a no choice receiving a majority of the valid votes cast, a runoff election shall be conducted between the labor unions receiving the 2 highest number of votes, provided that the total number of votes for all contending unions is at least 50% of the number of votes cast. In cases where the petition was filed by a national union or federation, shall be required to disclose the names of the local chapter's officers and members. At the expiration of the freedom period, the employer shall continue to recognize the majority status of the incumbent bargaining agent where no petition for certification election is filed. 268, 232, 232. Relations. 232. The Bureau of Labor Relations and the Labor Relations Divisions in the regional offices of the Department of Labor shall have original and exclusive authority to act at their own initiative or upon request of either or both parties on all inter-union and intra-union conflicts, all disputes, grievances, or problems arising from or affecting labor management relations in all workplaces, whether agricultural or non-agricultural, except those arising from the implementation or interpretation of collective bargaining agreements, which shall be the subject of grievance procedure or voluntary arbitration. The Bureau shall have 15 working days to act on labor cases before it, subject to extension by agreement of the parties, as amended by Section 14 Republic Act No. 6715, March 21, 1989. Roman numeral number 2-B, appeals from Med arbiters. Among the cases cognizable by the Med arbiters in their original and exclusive jurisdiction, only decisions in inter-union disputes, representation or certification election conflicts are appealable to the Dole Secretary by virtue of Article 272 of the Labor Code. All the others are appealable to the BLR Director. Roman numeral number 2-C, appeals from BLR Director. The decisions of the BLR Director, Bureau of Labor Relations Director, rendered in his original jurisdiction are all appealable to the Department of Labor Secretary, DOLE or DOLE Secretary, Department of Labor and Employment. Complaints. Number 1. Complaints and petitions involving the application for registration, revocation, or cancellation of registration of federations, national unions, industry unions, trade union centers, and their local chapters or chartered locals, affiliates, and member organizations. Number 2. Request for examination of books of accounts of said labor organizations under Article 289 of the Labor Code. Number 3. Intra-union disputes involving said labor organizations. Number 4. Notice of merger, consolidation, affiliation, and change of name of said unions and or petition for denial thereof. Registration. Number 5. Of multi-employer CBAs or petitions for their registration and contempt cases. 2-D. Appeals from POAA. Appealable cases. Under the two distinct 2016 revised POAA rules for land-based OFWs and seafarers and the omnibus rules, the Office of the DOLE Secretary has exclusive jurisdiction to act on appeals from the orders of the administration or the POAA in the following cases over which it has original and exclusive jurisdiction. Number 1, or letter A, all cases which are administrative in character involving or arising out of violations of recruitment rules and regulations, including refund of fees collected from land-based OFWs and seafarers, and any violation of the conditions for the issuance of the license to recruit OFWs. Disciplinary action cases against land-based OFWs and seafarers and principals or employers that are administrative in character, excluding money claims. Number 2, period to appeal. A party aggrieved by a decision of the POAA administration may appeal the same to the Office of the DOLE Secretary within 15 calendar days from receipt of the copy of the decision. Failure of the aggrieved party to perfect the appeal within the reglementary period shall render the decision of the POAA administration final and executory. The Docket and Enforcement Division shall not accept an appeal that it filed beyond the reglementary period of appeal. The period is 10 days in case of appeal to the DOLE Secretary of the order of the POAA administrator denying the motion to lift the closure order or motion to reopen. Any motion filed on the denial of a motion to lift shall be treated as an appeal. POAA cease to have jurisdiction over money claims cases. It must be noted that the POAA ceased to have any jurisdiction over money claims of OFWs or those arising out of an employer-employee relationship or by virtue of any law or contract involving Filipino workers for overseas deployment, including claims for actual, moral, exemplary, and other forms of damages. The jurisdiction over these claims was transferred to the labor arbiters of the NLRC by virtue of Section 10 of RA number 8042 as amended. Consequently, appeals from decisions of the labor arbiter may be instituted to the Commission. For comprehensive discussion on this topic, please refer to the notes and comments of Article 35 of the Labor Code found in Volume 1 of this 3-volume series, the Labor Code by the author. Number 3. Rule 65, certiorari. Roman numeral, number 3. Rule 65, certiorari petition from Dole Secretary's decisions. Number 1. Background. The Labor Code and its implementing and related rules do not provide any mode for reviewing the decisions of the Dole Secretary, which he renders either in his original or appellate jurisdiction. Yet, like the decisions of the NLRC, the Dole Secretary's decisions also become final and executory after 10 calendar days from receipt. NLRC, yet like the decisions of the NLRC, Dole Secretary's decisions also become final and executory after 10 calendar days. 10 calendar, so it's on the 11th day from receipt thereof by the parties. They may also be brought to the CA by way of a Rule 65 petition on certiorari even beyond the calendar days. Even beyond the 10 calendar day period. Even beyond the 10 calendar day period set in the Labor Code and its implementing rules for as long as they are elevated thereto within the 60 calendar day provided for. Rule 65 petitions under the 1997 Rules of Civil Procedure. 2. Pertinent legal provisions. In 2 instances, however, there is a specific mention of a remedy from the decisions of the Dole Secretary thus. Number 1. Section 15, Rule 11, Book 5 of the amended rules to implement the Labor Code, which provides that the decision of the Dole Secretary on appeal from the main arbitrator's decision on a petition for certification. Pertinent legal provisions. In 2 instances, however, there is a specific mention of a remedy from the decisions of the Dole Secretary thus. Section 15, Rule number 11, Book 5 of the amended rules to implement the Labor Code, which provides that the decision of the Dole Secretary on appeal from the med arbiter's decision on a petition for certification election is final and executory, but that the implementation of the Secretary's decision affirming the med arbiter's decision to conduct a certification election shall not be stayed unless restrained by the appropriate court. Section 5, Rule 5, execution of the rules on the disposition of labor standards cases in regional offices, which provides that the filing of a petition for certiorari before the Supreme Court shall not stay the execution of the appealed order or decision unless the aggrieved party secures a temporary restraining order from the court. According to the Supreme Court, there is no conflict with its pronouncements on the proper remedy, which is Rule 65, and which should be initially filed in the CA in strict observance of the doctrine on the hierarchy of courts. Accordingly, the appropriate court mentioned in number 1 above should be read as referring to the CA. The specific reference to the Supreme Court in number 2 above as the forum for filing the Rule 65 petition with certiorari is not infirm, since Section 5 cannot be read to mean that the petition for certiorari can only be filed exclusively and solely with the Supreme Court, as the provision must invariably be read in relation to pertinent laws on the concurrent original jurisdiction of the Supreme Court and the CA and Rule 65 petitions. In fine, it is procedurally feasible as well as practicable that Rule 65 petitions for certiorari against the decisions of the DOLE Secretary rendered under the Labor Code and its implementing and related rules be filed initially in the CA. Paramount consideration is the strict observance of the doctrine on the hierarchy of courts emphasized in St. Martin Funeral Home on the judicial policy that the Supreme Court will not entertain direct resort to it unless the redress desired cannot be obtained in the appropriate courts, or where exceptional and compelling circumstances justify availment of a remedy within and calling for the exercise of its primary jurisdiction. Illustrative cases. In the following cases, Rule 65 certiorari petitions were declared as having been validly filed with the CA from the DOLE Secretary's orders, resolutions, and decisions. In M. Ramirez Industries vs. Secretary of Labor, a sale was responding DOLE Secretary's order affirming the Regional Director's Act of having taken cognizance of a case filed pursuant to his visitorial powers under Article 128A of the Labor Code. In Samahang Manggagawa sa Permex vs. Secretary of Labor, a sale was respondent's order setting aside the med-arbitrator's dismissal of a petition for certification election. In Samahan ng Manggagawa sa Pacific Plastic vs. La Cuesma, a sale was respondent's order affirming the med-arbitrator's decision on the results of a certification election. In Field-Thread Workers Union vs. Confessor, a sale was respondent's order issued under Article 278G, 263G, certifying a labor dispute to the NRLC for compulsory arbitration. Number 4. Filing of a motion for reconsideration of DOLE Secretary's decision, a prerequisite to filing of Rule 65 petition for certiorari. A. The Peltranco Rule. The 2014 case of Peltranco Service Enterprises reiterated the rule on the mandatory filing of a motion for reconsideration prior to the institution of a Rule 65 petition for certiorari from the decision of the quasi-judicial administrative agencies, which in this case refers to the DOLE Secretary. Most notably, the decision herein rendered has clarified that while a government office may prohibit altogether the filing of a motion for reconsideration with respect to its decisions or orders, the fact remains that certiorari inherently requires the filing of a motion for reconsideration, which is the tangible representation of the opportunity given to the office to correct itself. Unless it is filed, there could be no occasion to rectify. Whereas the remedy of certiorari would be unavailing. Simply put, regardless of the proscription against the filing of a motion for reconsideration, the same should be filed on the assumption that rectification of the decision or order must first be obtained and before a petition for certiorari should be instituted. Letter B. Previous cases already enunciates the rule. As earlier stressed, the Peltranco Rule merely reiterated this well-settled rule which has been previously enunciated in the catena of cases. For instance, in the 2013 case of Lepanto Consolidated Mining Company versus Lepanto Capataz Union, which involves a decision rendered by the DOLE Secretary in an appeal of the med-arbitrator's decision in a certification election case, It was pronounced that petitioner Lepanto's failure to timely file a motion for reconsideration prior to filing its petition for certiorari in the CA rendered the decision of the Dole Secretary beyond challenge. To start with, the requirement of the timely filing of a motion for reconsideration as a precondition to the filing of a petition for certiorari accords with the principle of exhausting administrative remedies as a means to afford every opportunity to the respondent agency to resolve the matter and correct itself if need be. And secondly, the ruling in National Federation of Labor versus Laguesma reiterated St. Martin's Funeral Home, where the court has pronounced that the special civil action of certiorari is the appropriate remedy from the decision of the NLRC in view of the lack of any appellate remedy provided by the Labor Code to a party aggrieved by such decision. Accordingly, any decision, resolution, or ruling of the Dole Secretary from which the Labor Code affords no remedy to the aggrieved party may be reviewed through a petition for certiorari initiated only in the CA in deference to the principle of the hierarchy of courts. Number 4. Rule 43. Appeal to the CA from Dole Secretary's decisions as voluntary arbitrator. In the light of the grant of voluntary arbitration power to the Dole Secretary under Dole Circular Number 1 Series of 2006, the decisions rendered by him in that capacity may be elevated to the CA by way of an ordinary appeal under Rule 43 of the Revised Rules Court under the Luzon Development Bank Doctrine. Luzon Development Bank. Rule 45. Petition for review and certiorari to the Supreme Court from decisions of the CA. The only mode of elevating decisions of CA to the Supreme Court in cases originating from Dole Secretary, since the CA has jurisdiction over Rule 65 petitions for certiorari that may be filed before it from the decision of the CA of the Dole Secretary. Any alleged errors committed by it in the exercise of its jurisdiction would be errors of judgment which are reviewable by means of a timely appeal to the Supreme Court through Rule 54 petition for review of certiorari and not by way of Rule 65 special civil action of certiorari. Rule 45 is clear that the decisions, final orders, or resolutions of the CA in any case, example, regardless of the nature of the action or proceeding involved, may be appealed to the Supreme Court by filing a petition for review, which would be but a continuation of the appellate process over the original case. Under Rule 45, the reglementary period to appeal is 15 days from notice of judgment or denial of the motion for reconsideration. If the aggrieved party fails to do so within the reglementary period and the decision accordingly becomes final and executory, he cannot avail himself of the writ of certiorari. His predicament being the effect of his deliberate inaction. A petition for certiorari under Rule 65 cannot be a substitute for a lost appeal under Rule 45. Hence, it should be dismissed. This rule holds true especially if one's error in one's choice of remedy occasions as loss or lapse. Dole Secretary number 2. Dole Secretary, being a nominal party and not a party in interest, cannot be a petitioner under Rule 45. In the 2014 case of Republic vs. Nambuco, PIC, INC, it was petitioner Dole Secretary herself who elevated the case to the Supreme Court and not the private parties. This lead the court to decline resolving the constitutionality issue, which was the one being appealed by the Dole Secretary, and instead held that petitioner Dole Secretary, being a nominal party to the case, is not the real party in interest vested the personality to file the petitions. The Supreme Court justified its refusal to rule on the constitutionality issue in this wise. True, the issue of whether Section 17, now Section 19, Rule 8 of the Department Order Number 40-03 is unconstitutional is a matter of great concern and deserves everyone's attention. But this court cannot pass upon and resolve the same in these petitions, otherwise it will countenance the objectionable actions of the Secretary of Labor and run afoul of the above cited settled decisions. Let's have a short break. So that ends Article 224. We're already in Article 225, powers of the Commission. Let's have a break.